I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this lesson on New England state courts. This lesson is the second in our series on state courts, so if you haven't already, please view the introductory class for your respective state before moving on to this lesson. All classes can be found in our FOI guide at NEFAC.org, as well as on our YouTube channel, Five Freedoms. In addition to state courts, we also offer lessons on state public record and open meeting laws, as well as the Federal Freedom of Information Act. Each class builds off one another, and they all collectively provide a curriculum you won't find anywhere else. Before we begin today's lesson, a special thanks to everyone who is helping us make these classes happen. SBJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you for joining us for this webinar, which is brought to you by the New England First Amendment Coalition. Now, this session is going to focus on the courts in Massachusetts. We're going to go in a little bit more detail and talk about how to access court documents and hearings in Massachusetts. With us is Bob Ambrogi. He's the executive director of the Massachusetts Newspaper Publishers Association, and he's going to explain in greater detail how the courts work in the Bay State. Bob, thank you so much for being here.
Yeah, thanks, Emily, for having me. I'm really looking forward to doing this presentation. All right, and it also occurred to me that in this slide, I did not put my contact information anywhere, but I welcome you to follow up with me directly. My email address, if you want to write it down, is just my last name, Ambrogi, A-M-B-R-O-G-I, at legaline.com. That's legaline.com. And feel free to email me with any questions you might have. Let's just kind of talk about some generalities first before we get into the specifics. And first of all, I'm talking here about access to state courts. This is not about the federal courts, which have some slightly different rules, but we're talking here about the Massachusetts court system, pretty much all the way from the lowest level up to the Supreme Judicial Court, which is the highest court. And the general rule here is that unless there's some other exception, then the courts are open to the public, and that means to the press as well. This is a quote from an 1884 case where they talk about the fact that this is not just an issue, not just because we want to see, citizens' disputes played out in some sort of a gossipy public forum, but this is really fundamental to our system of democracy. It's fundamental that the public be able to see how government works, and that those who, as this quote says, those who administer justice should always act under the stare of public responsibility, and that every citizen should be able to satisfy themselves with their own eyes as to the mode in which the public capacity is performed. And a second point here is that the media's right of access to judicial proceedings is entirely synonymous with the public's right. The media has no greater or lesser right, with maybe a slight exception regarding using technology in the courtroom that I'll talk about. But our general right of access is the same as that of any other citizen or person in Massachusetts. And those rights kind of derive from a couple of different sources. A lot of it is simply just what they call, common law. The idea, this goes back to the British Commonwealth days, that people have always had a right to come in and watch court proceedings, and it goes as far back as history records in the common law system. There is also some constitutional right. The U.S. Supreme Court, not the Massachusetts Supreme Court, but the U.S. Supreme Court has held repeatedly that the First Amendment to the Constitution provides a right for journalists and other members of the public to attend criminal trials in most cases. The First Amendment possibly provides a right to attend civil or non-criminal trials. That hasn't ever firmly been decided by any sort of top appellate court. The Supreme Court has never ruled on that, and the Mass SJC has never ruled on that. But there is a general presumption that there's a basic constitutional right of access. And then in criminal cases, of course, the Sixth Amendment, which is the one that protects the rights of defendants in criminal trials, they also have their own right to have the public attend their trials to make sure that their trials are conducted properly. But so again, that's not absolute, and there are certainly circumstances where a judge can find that there is some sort of a compelling, overwhelming interest to exclude the press and the media. But that's very rare for the most part in a general criminal case. So I'm going to talk first about access to court proceedings, going into hearings and trials and whatnot, and then secondly about public records or court records access. Again, the general rule is that most cases are open. I've tried to put together a little bit of a list of the kinds of proceedings that are considered to be open to the public and to the media in Massachusetts. The sixth bullet point down there is probably the most important, which is, as I said, trials. I mean, for the most part, with very few exceptions, trials are open to the public. But also other kinds of hearings, arraignments, bail hearings, probable cause hearings, hearings to suppress evidence. You can go through this list on your own, and I think you will get copies of these slides, or this will be made available. So I'm hoping you'll be able to have this, and I don't need to go through it all in detail. But the general rule, again, is these things are all open to you, and you should be able to go in and access them. There are certain kinds of proceedings that are closed by default. Grand jury proceedings are probably the most important of those. We would all love to be able to go in and sit in on grand jury proceedings, but they are closed to the public. And there are rules against even making the transcripts of grand jury proceedings available to the media or to the public. Although there's been some interesting law around that issue. One of them has involved the issue when, say, a newspaper gets access to a grand jury transcript indirectly. Somebody leaks it out to somebody else, and somebody else gives it to a reporter, and the reporter has it. Can the reporter write about what was in that grand jury transcript? And the law has been pretty clear that yes, the reporter can write about what's in it. If it wasn't the reporter didn't sneak into the courthouse and steal it, somehow directly commit a crime to get access to the transcript, then otherwise they have a right to use that. Also notably, a grand juror, one of the people sitting on a grand jury proceeding, if they want to step out and talk about the proceeding to you, they can do that. The judge may have them under some kind of an order during the grand jury proceedings, but once the grand jury has completed its work, and if they want to go out and talk to you about what happened on the grand jury, they're totally free to do that, and you're totally free to report on it. Some of these other proceedings are pretty obvious. The juvenile proceedings, for the most part, are closed to the press unless it involves a juvenile who's committed murder over age 14 or a few other exceptions. An inquest is something that hardly ever actually happens, but that's a proceeding where a judge is looking into whether the circumstances surrounding a death in order to determine whether there may have been a crime committed with regard to the death. And then there are some proceedings where access is discretionary with the judge, where the judge can make a ruling onto whether or not to allow access. One of the sore points here is for the media has been the third bullet point here, magistrate hearings. These are clerk magistrate hearings in district court, which are where there's been an application to issue a criminal complaint, and the judge holds a hearing on that. Our organization, several other newspapers and press associations in Massachusetts went to court over that issue. trying to get a ruling that magistrate hearings are presumptively open to the public and should be. And we've got a ruling from the SJC saying that they can be open in some cases, but they are presumptively closed, unfortunately. So if there's a magistrate hearing that you know of, it's going to be a hearing in a district court where maybe a local, sometimes he's involved, very prominent local people get involved in some kind of a criminal allegation, generally a minor allegation. But if it's something you want to cover, you can go to the magistrate and make a request and make an argument for why this is in the public interest, and they can make a ruling in your favor to let you in. Again, a couple of things where there's absolutely no right of attendance, depositions, and lobby conferences. Now, I said before that the press has no greater or lesser access than the public, but this is the one exception in Massachusetts, and this has to do with using cameras and electronic devices in the courtroom. And there's a rule, SJC Rule 119, which governs this. And let me be very clear, some people have read this rule to apply to journalists going into a courtroom. It does not apply to that. Journalists can go into a courtroom without regard to this rule. The rule only applies to when you want to bring in a computer or bring in a camera and use that in the courtroom. So this is a rule that basically requires the news media. It provides certain parameters around using these devices in a courtroom. Significantly, it prohibits certain, I'm going to jump ahead to my slide here. Here's kind of the most important part here, which is that it requires news media to register with the SJC's public information officer prior to using an electronic device in a courtroom. Again, this has met a lot of resistance over the years from people in the press who feel that they should not ever have to register with any government agencies in order to cover the activities of government. And let me just say one more time, this is not about whether you can cover or not. You can cover without registering, but if you want to use a device, you have to register. And the rule defines who's eligible to register as news media, and it defines it as someone who, either an organization that regularly gathers, prepares photographs, records, writes, edits, reports, or publishes news or information about matters of public interest for dissemination to the public in any medium, whether print or electronic, and individuals who perform a similar function. Now, often, typically what will happen is if you're working for a large organization, if you're working for the Globe, like Emily, once your organization has registered, it makes it super easy for you. I mean, you can essentially show a business card or something else, and you're all set. But you don't have to work for a quote unquote mainstream news organization. You can be a blogger who regularly covers issues. Any kind of citizen journalist can qualify under this rule, but you do have to go in and register. Then let me just backtrack. I mean, once you have, then you can go in and operate these devices in the courtroom. A judge can set parameters around it, and there are certain kinds of recording that are limited, but as a general rule, you're then able to use these devices. If you want to go in and record or use a computer in a SJC appellate argument, there's a slightly separate rule that requires you to request pre-authorization from the clerk of the SJC before 4 p.m. on the day before oral argument, and then it's up to the clerk to decide whether to let you in to do that or not. So that's court proceedings. And again, to summarize, to say what I've said 10 times already, really is that as a general rule, most of those court proceedings are going to be open with certain specified exceptions. Now, let's talk about access to court records, which also has some unique rules around it. And, an important point to keep in mind is that the Massachusetts Public Records Law, which applies to other government records, does not apply to the courts at all, just as it does not apply to the legislature and arguably to the governor's office. But so you don't have a right under the public records law to get any court records. And that even extends to not just court case records, but court administrative or bureaucratic records. I mean, if you want records regarding the court budget or court management activities that have nothing to do with any particular cases in the courts, you can't get those under the public records law. You can ask for them, and the court will consider your request, but there's no right of access under the Mass Public Records law. But there is a rule put forth a couple of years ago by the trial court called Trial Court Rule 14, if I can know my Roman numerals, Uniform Rules on Public Access to Court Records. And this is the general guideline, the general document that, and I put a link at the end of this slide to how you find this, but this is the general document that's going to tell you what kinds of records you can access and how you can access them and where. Generally, it provides for three types of access. In a courthouse at the counter of the clerk's office, in other words, you walk up to the clerk's counter and say, I want this record. Or in a courthouse via a kiosk that accesses records electronically, or remotely versus via the public internet portal. And I'll talk more about all of those in a second. But first of all, what is a court record? The rule defines it as all or any portion of a court paper, document, exhibit, order, recording, docket, or other records that are made, entered, filed, and or maintained by the clerk in connection with a case. So essentially all of the documents, exhibits, and other materials related to a case. What is not a court record? Administrative records, which, as I said, deal more with the management side of the courts, the personnel side of the courts, and that don't have to do with particular cases pending in the courts. And under this uniform rule and under basic law of the Commonwealth, the general policy is that most court records are presumptively public documents unless required to be withheld from public inspection by statute, court rule, standing order, case law, or court order. So unless there's a statute, court rule, or some other kind of order or law, the records are presumptively open. And in a clerk's office, the court records are available for public access during normal hours, unless otherwise prohibited by court or law. So that means you can go into the clerk's office at any time and ask for these records. And there's a rule regarding allowing judges to impound records, which closes them to public view, and I'll talk about that in a second too. But so here's where the rules make some distinctions in terms of what you can access and how you can access them. So within a courthouse, this is you get the broadest access to records by going and asking for them in a courthouse. You can go into the clerk's office, submit a request, and you can also look at them at a computer kiosk or terminal located in the courthouse. And there's no fee to access, and you can get access to pretty much any record by doing that, again, unless it's been closed for some legal reason. And you can get them you can get paper copies, you can get printouts of electronic materials. You can, if the court has a copy machine, you're entitled to get them copied, although they can charge you a fee for that. If there are audio-visual recordings, they have to provide those as well, although again, they can charge some fees for media that they reproduce them on. And whatever format they might be in, whether electronic or whatever, they should reproduce them for you. The rule even specifically provides for you going in and using your own device to duplicate a court record, meaning if you want to take photos with your mobile phone, you can do that. If you have some kind of a small scanner or something like that you want to bring in, you have the right to do that under these rules. Although again, you always need to check with the clerk on this and make sure it's all appropriate there. Now, another kind of sore spot for the media over these rules, when these rules were enacted, what was it, 5 years ago or so, it deals with getting court data. Now, the rules do provide for you to request compiled data. And to get compiled data, you need to, again, go in and make a request to the court administrator's office about what data you're seeking and the purpose for which you are seeking it. And the rule specifically allows these kinds of requests by the public for scholarly, educational, journalistic, and other purposes. But by compiled data, they're basically saying, you're asking for something with some specificity. You want data on, I don't know, all DUI cases dismissed for a particular reason during this time period, or something like that. And they have to provide that to you. Although again, they can charge you a fee for getting that data. What the rule prohibits the court from doing, and which was to the chagrin of many reporters, is providing bulk data. And there are reporters out there who would like to be able to get access to the court docket data in bulk, so that they could go in and kind of run various kinds of analytics and searches across it, and look for trends, or analyze, look for something that stands out that they don't even necessarily know to ask for in the first place. But the courts have said that is not available. Now, these rules provide sort of different standards with regard to remote access to court records, and that's going into the court's public access website online, and through that online system, you can search for cases by party name, case number, or various other criteria. But you're limited in what you can get. You're not going to get the full documents. You're going to get, as it lists here, the name of each party, related case or case numbers, names and mailing addresses of attorneys who entered an appearance for the party, the docket of a specific case, which is not, the docket isn't the documents, it's sort of the listing of events that have happened in that case, and any calendar information of hearings that may be coming up or something like that. But so that's a lot less than you can get by going into a clerk's office, where you can actually get the physical or electronic documents or other materials associated with the case. And that's in civil cases. In criminal cases, you're actually even slightly more limited. Again, you can get the name of the defendants and the related cases and whatever else. But the way you're limited here is that you can search only by case number for criminal cases. So you can't search by a name. If you're looking to find out if there has been a criminal case involving John Smith, you would have to know in advance the docket number of the case for John Smith in order to be able to find out anything about it on the online system, which is really limiting in terms of the usefulness of that tool. And I don't need to go through all of this, but something else this rule does is provide a list of records excluded from public access. And this list is pretty much drawn from what had been already decided to be excluded from public access by case law over the years, or by court rule or other means. I'm not going to go through all of this. You'll get the slides, and you can read through it. But there clearly are a number of types of records that you simply will not be able to get, whether you go into the clerk's office or try and do it online or any other means. I've gone through and kind of done a flip side of that, in a way, of some of the records that therefore are available, or you should expect to be available. And again, I don't know if it's a good use of our time for me to go through all of this, because I'll give you this PowerPoint. But there's 2 slides on that, and I think I'm sure I probably missed something, but I've tried to get as many categories on here as I could think of. And then there are, excuse me, there are some records where it just continues to be a matter of discretion, and where you may actually have to ask a judge, or a clerk may look for information from a judge as to whether to provide them to you. There is a procedure also in Massachusetts it's important to know about regarding impounding records, and parties in a case can ask a judge to impound the records in a case, and once they're impounded, they are closed to public view. The second to the last paragraph on this page basically sets out what the standard is here, which is the court shall consider all relevant factors, including but not limited to the nature of the parties in the controversy, the type of information, the privacy interests involved, the extent of community interest, and the reasons for the request. But there's a general balancing act that it should be only in extraordinary circumstances that a judge impounds a case. I think, unfortunately, the reality is that judges are a little bit freer about doing this than they should be. But significantly for the news media here, if you know that there's of a request that's been entered to impound records, but maybe it hasn't been entered yet, the news media has a right to ask the court to give them an opportunity to argue against the impoundment. And again, this is covered in the third paragraph here, where it says the court may order notice be given to interested third parties, such as the media, and you can go in and argue with the judge. You don't have to be a lawyer to do this. It might help you. You might be better off if you have a lawyer, but you can oppose these impoundment requests before they're entered. Once they're entered, they're a little bit harder to lift, and then at that point, you might need to get a lawyer to try and get that done. Grand juries, I've talked about that already, but as a general rule, those records are not available. I don't know that I need to cover this if you've talked about the courts before in any of these programs, but judges themselves, there's no law against calling a judge and asking him for comment. A lot of reporters are sometimes reluctant to do that, but judges are required by their own judicial conduct code to abstain from public comment about pending or impending proceedings. So they're not supposed to comment on cases that are immediately pending before them. Now, some judges interpret this more or less liberally. I mean, there are judges who might say, well, I can't comment on the specific facts of this case, but I can tell you that generally speaking, the law in Massachusetts is such and such, or generally speaking, here's how we handle these types of matters. And you will find judges who are more willing to make those kinds of comments. You can also, reporters, again, are somewhat reluctant to do this, but you can sometimes get Judge A to comment on the case pending before Judge B. And there's actually no prohibition against a judge doing that. Although, again, the judges are pretty reluctant to make those kinds of comments. But again, if a judge wants to make comments that sort of generally talk in an educational way about what the law is about a certain kind of case, without getting too specific as to the facts, they are free to do that under the rules. Same with lawyers. Lawyers are kind of shy often. Well, some lawyers are not in the least bit shy. Other lawyers are very shy about talking about their matters. But the restriction on them is that they shouldn't be saying anything to the press or the public if they think it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in a matter that they are participating in. So, again, we see lawyers all the time out making statements about cases they're involved in, but they will be somewhat constrained, and perhaps in some cases, in trying to getting too much into the facts or specifics of a case, especially if they feel it may skew the case one way or the other. I've put a bunch of resources at the end of this slide of links. These are all links to some of the items I've talked about here, but Rule 119 is the electronic access to courts rule. There's a link to the page for news media to register under Rule 119. There's another page that lists the news media that is already registered under Rule 119. There's a page from the SJC on its protocol for news media access to its courtroom, link to the Public Information Officer, the Judiciary Media Committee, court basics. This is a document I think the court put out on Informational Guide for Journalists, rules on impoundment, the rules on public access, and trial court electronic access. Just a quick note about the Judiciary Media Committee. I'm on this committee. This has been a committee that's been around for, I think, since the 70s or 80s, actually. And it's a committee of lawyers, judges, and members of the media. And the purpose of this committee is to kind of serve as an intermediary among those three groups, and particularly as between the courts and the media. And it doesn't get too many of these requests anymore. It used to get more of them. But if you are having an issue with access to the courts that you're not able to resolve with the clerk or through the local court officials, you might want to take it to this committee. That's part of what it exists for, is to try and serve as an intermediary to resolve disputes over access to the courts by the media. Certainly take it to the SJC's Public Information Officer, and she can often help resolve the issue. But if not, it can kind of get moved to this Judiciary Media Committee, and they can sort of convene as a little bit of a SWAT team and see if they can resolve it. There are issues where you just may need to end up having to get a lawyer if your access is getting blocked, and of course that's not a good option if you don't work for a big news organization with lawyers on the payroll. But there has been some talk, I know, by the Reporters Committee for Freedom of the Press about setting up a free media resource here in Massachusetts. I don't know where that stands, but that may be something to watch out for down the pike, where they would provide lawyers on a pro bono basis to journalists with access issues. But so that's all I have.
Bob, thank you so much. That was a really great overview of accessing court records and hearings. And only one question came up while you were speaking. I didn't interrupt. Someone asked if you had to share your opinion on domestic violence and sexual violence cases. Apparently, Allie Jarmanning at BUR has done some reporting on this. Do you believe the Massachusetts law should stay as is?
Are they? I'm not sure if they're talking about the police reports issue or the.
I'm not sure
if
whoever asked the question, if you can clarify that a little bit.
I mean, I know, I guess I think there's been a few different issues. I'm not sure what Allie Jarmanning has been reporting on it, but I know one issue was a few years ago, the law was changed so that police records would no longer be public with regard to complaints of allegations of domestic violence or sexual violence. Mm-hmm. I know at the time when that law was changed, I actually opposed it because I felt that was actually protecting the perpetrator more than protecting the victim, because what was happening was reports of individuals involved in sexual violence were not being made available to the public, and and often in some cases the police also wouldn't follow up on these matters, and people were then able to commit acts of violence a second or third time before it finally led to some further consequences.
Yeah, no, I know as a reporter, it's, anything to do with domestic violence and stuff, it just gets completely redacted, or we don't have access to it. It's really tough. We have another question too. And just to clarify, the person who did ask the question said, yes, it was about police records. So,
yeah.
And so Maggie Mulvihill asks, has the Judiciary Media Committee done a study of any kind on of the number of types of cases that have been impounded in recent years, or has anyone looked at this? I recently reported on a judge in Middlesex County who impounded documents for 50 years with no explanation until 2072, and no justification provided for the impoundment of the documents. So has anybody really looked at this?
First of all, hi, Maggie. Good to see you out there. And second, the Judiciary Media Committee has not, I don't know of anybody who has. Where's Todd Wallach when you need him? That looks like the kind of thing he would have gone into at some point. But I don't know of anybody who's studied that. I think, yeah, it would be a great project to go into. I think the other thing is, I mean, there are you just need to challenge those things. Those impoundment orders can be challenged and taken up on appeal. And I think, as I said during the presentation, I think judges are just too free to issue impoundments without really following the standard. You'll find judges. I hear stories from lawyers who talk about judges who don't even realize there's a rule on impoundment. They'll just issue an impoundment sua sponte without, even going through the procedure provided by the rule. So it's a really abused area, I think, of the procedural rules in Massachusetts.
Yes, and definitely frustrating for reporters and editors, that's for sure. I don't know if there's any other questions, but Bob, I want to thank you so much for this presentation. It was really helpful. We have folks in the chat who are thanking you too, including Maggie. And she said, thankfully, Judge Patrick Hagan unimpounded those records. Thanks, Bob and Emily. So thank you, Maggie, for tuning in, and thank you, everybody else. We had quite a few people tune in for our live audience today. I just want to encourage everybody to check out our previous episodes, which you can find on NEFAC's website, nefac.org, and on our YouTube channel. And Bob, thank you so much for taking the time to do this.
Thanks for including me, Emily. Thanks to everybody.
Excellent. Thanks, everyone.
See ya. Bye.